Arbitration is a formal process in which an independent arbitrator, acting like a judge, makes a decision called an award, which is binding on the parties. It applies to commercial disputes both domestically and internationally. Commercial contracts have a wide range. Typically, commercial contracts provide for dispute resolution in specific clauses. This allows for arbitration as opposed to litigation in quite a number of these contracts. Take, for example, if you buy a house. All contracts for the sale of land and houses in Ireland contain provision for dispute resolution, and typically this is arbitration. So if you are in a dispute in relation to a house, you cannot go to court to resolve that dispute. You must go to arbitration. If you do go to court, you will be stopped or stayed in your proceedings to enable arbitration to take place. Once appointed, the arbitrator sets up a preliminary meeting with the parties to enable a timetable to be agreed and a procedure to be agreed for the submission of documentation and to set up the date of the hearing. At the hearing, which is very similar to a court case, the parties and their representatives are examined and cross-examined. Evidence is heard, submissions made in writing, expert reports are exchanged, and a decision is reached by the arbitrator based on the evidence and on the submitted documentation. At the conclusion of the hearing, the parties may make written or oral submissions to the arbitrator. The arbitrator makes his or her decision based on the evidence and the submissions of the parties. This is given to them in the form of an award, from which there is little if any appeal. Awards are upheld locally and internationally through the New York Convention. One of the main advantages of arbitration is that it is a private process. Arbitrations are quite regularly held in these offices. One of the main differences between arbitration and litigation is that in arbitration, the parties can choose the arbitrator. Alternatively, the arbitrator is chosen by an institution. And unlike litigation, the arbitrator will be an expert in their own field. This is very dissimilar to courts, where the judge is not an expert in the field in which the dispute lies.